harassing the police every single day.
Sheets v. Judge Bell. Civil action. Case number 2:22CV00035 JLB KCD. $30 million lawsuit for violating free speech. Cause of action. Claim 1 First Amendment violation. The plaintiff has a clearly established constitutional right to free speech on a public sidewalk, which is the ultimate public forum. And the defendant clearly and maliciously destroyed all of that. Claim 2 Second Amendment infringement. The plaintiff has a clearly established constitutional right to bear arms and defend himself, and the defendant has clearly and illegally taken that away for a misdemeanor offense of free speech on a public sidewalk. Claim 3 The Fourth Amendment/Molly Couse prosecution. The defendant instituted a criminal proceeding against the plaintiff. The defendant did not have probable cause to institute a criminal proceeding against the plaintiff. The defendant instituted criminal proceeding against the plaintiff because the plaintiff was causing complaints and not because the plaintiff was violating any laws. The defendant acted with malice and is still acting with malice as we speak. Claim 4 Fourth Amendment/unlawful arrest. The defendant did not have probable cause to proceed with prosecuting the plaintiff. Because free speech is allowed on a public sidewalk. Defendant knowingly violated the First Amendment, free speech. Claim 5 Fourth Amendment/unlawful detention. The defendant knowingly illegally jailed the plaintiff for 30 days for free speech on a sidewalk and free speech online, which are the ultimate public forums. Claim 6 Fourth Amendment/unlawful seizure. The defendant and his probation officer illegally seized the plaintiff's gun, even though the plaintiff was doing as the defendant's probation officer asked him to give away the guns, and then turned it into a crime. Claim 7 14th Amendment violation. The defendant did deprive the plaintiff of life, liberty, and property. And the defendant did deny the plaintiff of equal protection of the laws. Claim 8 conspiracy. The defendant did work with 2 or more persons to conspire, for the purpose of depriving the plaintiff of the equal protection of the laws, or of equal privileges and immunities under the laws. The defendant did work with 2 or more persons to conspire to find the plaintiff guilty of free speech on a public sidewalk, which is the ultimate public forum. Claim 9 deprivation of rights under color of law. The defendant did act under color to willfully deprive the plaintiff of the right to free speech on a public sidewalk, and his Second Amendment right, and his right to defend the plaintiff's self. The defendant subjected the plaintiff to the crushing weight and burden of the criminal justice system every day for 17 months. The length of time between when the plaintiff was arrested and is still being prosecuted. We are in the appeal process as we speak. The defendant then tried to jail plaintiff and violate plaintiff's bond for not being at a calendar call, which plaintiff did not by law have to be there. And plaintiff lawyer was there. The plaintiff asked the defendant for motion to dismiss 3 times and was denied every single time. The defendant knowingly found plaintiff guilty of free speech on a public sidewalk. Defendant then told the plaintiff, you can't have free speech there, but you can anywhere else. Defendant then told the plaintiff, I want you to think about those bad words when you are doing your community service. Then put him on probation for 1 year. Fined him $215. And gave him 100 HRS of community service and took his guns for a misdemeanor and any form of self-defense. Defendant then had plaintiff arrested again 3 days later for free speech again. Then plaintiff asked for a bond and the defendant used an illegal law denying a bond. Plaintiff then had a hearing to get the bond anyways. And then finally the defendant gave a bond, but said you could not use it until 30 days later. Plaintiff then asked the defendant in a habeas corpus, how can you do this? This is illegal. The defendant then asked the state attorney's office, what say you? They told the defendant, you cannot do this, there is no case law. And the defendant said, I will do what I want. The plaintiff finally got out 30 days later and is now in fear every single day of illegally being violated for probation again and losing his car to the bond. The defendant then made a plea offer that if the plaintiff stay off the internet and do not post any more stories of police court and government corruption, and he would not jail the plaintiff for VOP violation again. The plaintiff is independent reporter for 10 years. Plaintiff declined the offer. Plaintiff then filed a complaint with the Judicial Qualifying Committee of the defendant's illegal acts of violating the Constitution. Then the plaintiff filed a motion to recuse the defendant. Because plaintiff was in fear of retaliation from the defendant for filing the complaint. The defendant was not supposed to hear this and did the hearing anyways. And denied it. The plaintiff is now waiting to go to trial on the VOP violation. The defendant subjected the plaintiff to the daily dread and horror of facing the possibility of another arrest at any time. And jailing again without bond. And the possibility of plaintiff losing his car to the bond. And losing more time away from plaintiff's family, friends, church, and losing more business from the plaintiff's home cleaning company. Plaintiff also in fear every single day because the defendant through the probation officer stripped him of his guns. And anything that can be used as self-defense. Including pepper spray. Because the defendant and probation officer said I'm a threat to the building where plaintiff protested abortion. Plaintiff informed them he has been assaulted 8 times. And none were charged. And has multiple stalkers for plaintiff's beliefs and causes. Defendant and probation officer have also stripped plaintiff's wife from any forms of self-defense including pepper spray. Defendant has caused plaintiff to spend $21,000 so far. In court fees and fines, community service, lawyers and bonds. The plaintiff asked the defendant motion to dismiss a total of 4 times throughout this 17 months and was denied every single time. The defendant caused the plaintiff to be deprived of free speech and has taken away his firearms and any form of self-protection. Defendant tried to destroy his family and livelihood for 30 days. The defendants caused the plaintiff loss of dignity, loss of privacy, and loss of status. Caused the plaintiff to be subjected to mental and emotional anguish. And caused the plaintiff to be subjected to fear and anxiety. Regarding each claim against the defendant.